Hello, IP friends. Welcome to another episode of IP series with Reader. So today I'll be talking about a case whose judgment was given since September last year, and all of a sudden last week, it just went viral, and I was like, "What is going on, guys?" So I'm not sure if you know the case I'm talking about, or if you've heard about it, but if you haven't seen it, turns out another telecom company was got a judgment against them, and they have to pay someone 20 million naira. 20 million naira, guys. I mean, it's not looking as if that's like the fixed rate for copyright or IP related dispute in Nigeria. I know we've had one more than, I think it was about 100, and it was against a TV station over a program that was being aired without the consent of the owner. But yeah, welcome to today's episode. This is your first time listening to me. I talk about everything intellectual property, from copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication. And my name is Rita and Richard. And for my returning listeners, you guys already know the drill. Thank you so much for always coming back to listen to me, and for liking, sharing, favoriting, subscribing on any of the platforms. I have a newsletter. Please subscribe to it on Substack. I also have a podcast which is hosted on Anchor and distributed on Spotify, Apple Podcasts, Google Podcasts, and several other podcasts. Just type IP series on Google and you will see me pop up. But yeah, let's get into today's conversation. So guys, welcome back to today's episode, where I'll be discussing the case between Adewale Ojo and Airtel Network Limited. Now, Adewale Ojo is a famous filmmaker, actor, show business personality, and also very handsome. He at some point won the AMVCA Viewers Choice Award, and I mean, I get it. If you've seen his movies, you understand why. But yeah, he sued Airtel Nigeria for using his photos and image for adverts between December 2014 to April 2015. So last week, all of a sudden, this story just went viral. I saw it in the group, and then I have this colleague who always sends me IP related cases every time he sees it, and I'm like, guy, I've seen this already, but I always tell him thank you. So yeah, if you're listening to me today, I say thank you for always sharing. Don't stop sharing. I really do appreciate you trying to keep me abreast and all of that. But yeah, it just went viral, and I was like, then I clicked the link and I saw that the judgment was attached, and I was like, okay. And I was going through it, and I saw that the judgment was given September last year. And I was like, how come I missed this? How did I miss this? Last year, gone. Anyways, so I read through the judgment. Luckily for me, it wasn't a long page document. Oh, gosh. It's not like I don't like reading document with so many pages. It's just that it takes me a lot more time to go through it, because I have to be very thorough. I have to read to understand, so I explain it to you the best way I understand. But yeah, I started reading through that, and it turns out that Airtel had already, they had previously had a relationship with him, not dating. You get, he signed an agreement with Airtel to do an advert. So it was like an exclusive arrangement for a mobile no portability advert, and it was meant to be for 1 year. But the 1 year expired, and Airtel, in their wisdom, thought that, okay, as we don't collect this pigeon at infinity, we're gonna max it out until we are tired. And Mr. Wole Ojo wasn't having any of it, because he was like, these people are trying to exploit my influencer capability. I mean, when you're a celebrity, everyone feels like, just one post we go viral. Or there's this perception people have when they see a celebrity affiliated or linked to a brand. It kind of builds trust. and also gives the brand more followers and customers, and patronage as well. So they decided to exploit that part of it. He was like, not having any of that. You guys are not going to exploit my image, my work, my brand, my goodwill. It's like, okay, let me not even go there. I was going to say one of these famous African proverbs, but yeah, I'm not going to do that. But that was, that's like the long and short of the case. So it turns out there's also a middleman in this case, they are called Prima Garnet. So they are more or less Airtel's agent. They act as Airtel's agent. They get models and actors to, come on board to work for Airtel. So the contract wasn't shared for us to know what really transpired, what was agreed upon, but the crux or the main dispute was centered around copyright infringement and unauthorized use of his image and photos. So I'm going to get into all of that. Trust me now. Now, when this case started, the documents that Mr. Adewole's Ojo's lawyers tendered included his written statement of oaths. If you're not a lawyer, apologies for that, but that's like your own version of what happened. He also tendered 4 photographs, a letter, and then a letter of demand. Those were the documents that he submitted. But I think my first question before I delve into what the court considered is first the 4 photographs that he submitted. Is it that he took them himself and submitted it to Airtel, or the Airtel do a photo shoot for the advert? Like, how was it done that the court concluded that he owns the right to those photographs? Because under the Copyright Act, the first person who creates the work is recognized as the author. However, where you were commissioned or employed and you have a written agreement stating that you transfer all the rights to either the commissioner, the person that commissioned the work, or the person, your employer, then, these two categories of people become the new owner of the work, and they have the right to commercialize and exploit the copyrights in that work. You also get to enjoy the exclusive rights of, they have the right to reproduce the work in any material form, to publish it, to perform it. Okay, I'm not going to include perform, but yeah, produce, reproduce, publish, make any cinematograph films or record in respect of the work, distribute to the public for commercial purpose. Those are the exclusive rights accorded to the owner of a copyrighted work for literary and artistic work. Now, under the interpretation as which is in section 51, it also defines photographs to be not comprised in a cinematographic film that is listed under the definition of artistic work. So, photographs not comprised in a cinematograph films enjoy copyright protection. Now, I mean, I guess what I was trying to reason is how did the court come to the conclusion that Mr. Wale Ojo retained copyright in his pictures? I mean, the 4 pictures that he tendered. I mean, they were in detail as to how this authorship or ownership came about, but they just concluded that okay, he owns the right his copyright to the photograph. So I'm just thinking that the contract in question specify under the IP clause that photographs taken in the course of this work belongs to Mr. Wole Ojo, or at the expiration of this contract, ownership reverts back to Mr. Wole Ojo. I mean, I don't really I hope someone answers that question for me as well, because I don't know, guys. But yeah, that's one of the issues I had with the case while reading it. Who actually arranged to take the photograph? Was it Mr. Wale, or Prima Garnet, or Airtel Network? I mean, because so there are speculations that we don't really have under the new copyright bill. No provision was made for image rights, and I'm wondering why. I mean, we keep seeing issues where someone uses someone's image and photograph, then you have that dispute as to who should own the copyright in that case. Is it the muse or the photographer? I mean, I talked extensively about this in the Banire case, Oluwadamilola Banire case against her employer, former employer, where they had used her image for commercial purpose without informing her as to why they were taking her photographs. They just, took the photograph of her and went into a channel licensing agreement with NTA Star TV, and she only got to find out about when she saw her pictures being displayed in Akure on billboards and on billboards in Akure and Abeokuta for promotional purpose. And she went to court and sued her former employer for 50 million, and the court in this case now said you're the one that owns the copyrights in that photograph, nobody you get. And I'm like, waiting the soap, because well, we already know that photographs are eligible work under copyright. Now, does it also mean that the mere fact that I was featured, say Banire or Mr. Wole Ojo was being featured in the picture, does it give the person that took the picture control over how the picture can be used? Sadly, the answer is yes, in line with Section 10. But I already stated, or I already explained when someone can be an author and when someone can be an owner. So make sure that when you're reading your contract, if you see author, know that it's the first person that crazy. Well, while an owner of an IP is the person that gets to monetize and exploit and commercialize, and do everything that is required of a copyright owner. Now, the things the court considered was, first, whether Wole Ojo can claim ownership of copyright. If Wole Ojo can claim ownership of copyright in the image, and they relied on Section 6, which talks about the exclusive rights that copyright owners get to enjoy if it's a literary or artistic or a musical work, or musical work or cinematography work. They also relied on Section 11, which talks about assignment and licensing. So I'm just going to read bits of it. So first of all, it says copyright shall be transmitted by assignment, by testamentary disposition, or by operation of law as a movable property. So I can transfer my right to you and ask you to do whatever it is you want on my behalf. It's just like when musicians assign their rights to collecting management organization or collecting societies to get their royalties on their behalf. And it goes further to say an assignment or testamentary disposition of copyright may be limited so as to apply only to some of the acts. So it's not like the whole act, just some of the acts which the copyright owner has exclusive right to control or to a party only of the period of the copyright, or to a specified within a specified country or geographical area. So sometimes you see in your agreements that when they're talking about use of the work, you can only use it within Nigeria. Sometimes you see globally or all over the world, for a term, for the duration of the contract, or for a term of 2 years subject to renewal if parties are okay with blah blah blah. You get. Then it goes further to say that's on subsection 3 now. Section 11 subsection 3, yeah. So no assignment of copyright and no exclusive license to do an act of which is controlled by copyright shall have effect unless it's in writing. So let's say, for instance, that Mr. Ojo, that's Wole Ojo, gave Prima Garnet license to use his photograph. They ought to have done that in writing. So I believe they did that in writing because they tendered the contract in court. And without a written agreement, your license or the license you've gotten or the assignment you were given will not be effective. So make sure you are dotting your I's and crossing your T's, appending or putting your seal or something. Sign those agreements. And it goes further to say, Section 4 says, a non-exclusive license to do an act of which is controlled by copyright may be written or oral. But in this Wole's case now, the contract was an exclusive one. So it was just between Wole and Airtel Network Limited, not Wole, Airtel Network Limited and others. Sometimes I understand that for agencies, modeling agencies or people that work, it's part of your portfolio where you put in photographs that people can use if they want to, and then you sign an agreement with them as to the use, or a release form with them saying, okay, I have given you the authorization to actually use this photograph. So I mean, this is just me speculating, but you guys, so I'm just gonna stop there. Then it talks about okay, I think I read 10 and 11. Have I? So 10 is first ownership of copyright. I already talked about that when I was explaining what ownership and authorship means. And then I think this is the section that most people don't really take note of or pay attention to, and that is subsection 3 of section 10, which says, where is a literary, artistic, or musical work? Remember that under the Interpretation Act of the Nigerian Copyright Act, photographs are already classified as artistic works. So it says, if where a literary or artistic work or musical work is made by the author in the course of his employment or by the proprietor of a newspaper, magazine, or similar periodical under a contract or service or apprenticeship, and is made for the purpose of publication in a newspaper, magazine, or similar periodical, the said proprietor shall, in the absence of an agreement in the contrary, be the first owner of the copyright in the work, insofar as the copyright relates to the publication of the work in any newspaper, magazine, or similar periodical, or the reproduction of the work for the purpose of its being so published. The author shall be the first owner of the copyright in the work. So it still makes emphasis on the first person who creates the work. So let's say it was Mr. Wole Ojo that was the first person that created the work. He is the author, and you cannot do anything without his consent. So in summary, consent, permission, and authorization is very important when you're interacting or trying to use the IP work belonging to some other person. Now, I don't have access, like I said, I don't have access to Wole's contract, but Wole, I want to believe that Wole also had a contract with Prime Garnet Limited, who Airtel Nigeria used as their agent when hiring models or actors. And Airtel Nigeria was trying to rely on the clause which stated that Wole Ojo's pictures or image would be used in perpetuity. I mean, I don't understand. Why do people that like why do you like to impose a forever and ever kind of agreement or relationship with someone that doesn't even want it? And again, well, if you're giving an agreement, please give your lawyer to read it, because I always when I see those clause I have in perpetuity, I always make my suggestion. Please, for the duration of the agreement, subject to the agreement of parties that they consent to renewing these agreements. I don't like it. It kind of makes me feel like a slave relationship? Why are you putting in perpetuity? So they're relying on that clause that they were going to use Wole's picture in perpetuity. And the court interpreted and said that the subject, that it was subject to Wole Ojo's fee being paid. But unfortunately, the amount that Airtel had offered to Wole say, reach. I mean, come on, I'm an AMVCA viewers choice already. Why not go give me this kind of amount? I mean, if they really wanted to work with him, they should have done a lot better, because I think it was also stated in the agreement that the only reason why he would consent to then continue their relationship was if they paid his fees. But unfortunately, that wasn't done, and then the contract elapsed, and so that means the contract ceased to exist the moment it elapsed, and Airtel can no longer use Mr. Wole Ojo's images and photos for any of their mobile no portability service or any other service. I mean, it's best that you always stick to your terms and conditions. The terms of your agreement, always try to stick to it, guys. Else, you're going to be violating and breaching. No, but you'll be violating the terms of the agreement. And in this case now, this has amounted to an infringement dispute or an infringement suit that has now added extra 20 million naira debt on next. Why am I about to say Netflix? Oh God, please. For Airtel, Egbami. But yeah, and when Airtel chose to use the image, there was no existing contract between the parties. So clearly, that is an infringement and a breach and a violation. On issue number 2, the court's thoughts. Did Airtel Network Limited infringe on Wole Ojo's copyright? And they said yes, they actually did, because when they chose to use this image, there was no existing contract, because the contract is what was binding both Wole and Airtel for in an exclusive arrangement for 1 year, and because that is no longer existing, we got move, man. So, but I'm still wondering, the copyright infringement that they're talking about. Anyways, I hope someone can share the documents. I mean, we need more documents to be able to determine how the court came up with the in its wisdom, came to the conclusion that Wole Ojo's copyright was infringed. I mean, the 4 photographs that were shared, attended during the sitting or the proceeding. Let's see and reason is going, like, okay, now I get it. But yeah, let's just for now assume or reason with the courts that Mr. Wole Ojo's photograph and image was infringed. Now, the final issue that the court raised was, is Mr. Wole Ojo entitled to any damage, any compensation? And the court said, after assessing the case, we are going to award you 20 million naira instead of the 100 million naira you were asking for. I mean, when you're asking for compensation or damages, it's always very tricky, because one, you have to show and prove what you actually lost. If you lost anything, you have to do evaluation of the market. So between December 2014 and April 2015, if I had gotten another brief, I would have been paid XYZ and I would have made this amount of money, And then in their proceedings, the lawyers to Mr. Wole also asked the court for attorney's fee, but the court was like, I know they give. So lawyers no get, they weren't awarded anything, just Mr. Wole. But I'm sure Mr. Wole has paid, or he and his lawyer already agreed to some sort of payment arrangement. But yeah, kudos to his lawyer, Mr. Olumide. He's a guru in data protection, so you guys can check him out. He also has a book on data protection as well, so check him out. Then finally, the courts bad. They restricted, they imposed an order that Nigeria, that's Airtel Network Limited, and its agents, including Prima Garnet and all the other agent representatives, assignees or officers, so they should not again, they should stop violating Mr. Wole Ojo's copyright. Bam. Hit the gavel. I don't have a gavel, but I had to use my pen to do that. But yeah, you get. So we've covered the part of the court. Now let's get into matters arising. This is where I now, flex my muscle and like, okay, let's look at other things that are silent but not so obvious in people's face. Like, I'm not being in your face, I'm not being in your face. Yeah. So let's get into that. My first matter arising will be, is this decision different from the Banires case where her image was used for promotional purposes without her consent, permission, or authorization? But the picture in question was taken by her former employer, Virtual Media Network Limited, who entered into a channel licensing agreement with NTA Star TV. And the courts in that case, in its wisdom, ruled that Banires' photograph or her photos belonged to her former employer, and dismissed all of Banires' case. Whereas in this particular one now, Wole Ojo's image and photos were used. I mean, this question keeps coming back to me. Was it the photos that he took himself, or he had paid the photographer and all the rights were assigned to him, or it was Airtel, one of their promotional pictures that they had of him, or was it included in his agreement that whatever photograph that was taken during the arrangement between Airtel and Mr. Wole will be transferred back to Mr. Wole? I really do not know. Banires' claim on image rights was also thrown out. Also the thought of personal was also thrown out. While in this case, they particularly focused on copyright infringement, and we know that copyright infringement happens when someone uses your copyrighted material without your consent, first of all. Then they try to exploit and violate the exclusive rights given to you, such as right to reproduce, right to publish, to broadcast, to translate, adapt, depending on the kind of copyrighted work it is. Wole's own was that it was a copyright infringement of his pictures and image, the unauthorized use of his brand, his image, and photographs without his consent. So you guys should just let me know. Maybe you send me a voice note or an email. This is a very interesting case, and when I did the LinkedIn post, I got good feedback. I'm still looking at the numbers, anyways. So for this year so far, that's like my most read post. I think that's because people are really interested in seeing what has really transpired. But then again, I looked at it from another side. Is this like, when I sue someone for unauthorized use of my photographs or pictures or images, do I necessarily need to be a celebrity in order for me to, for the court to award, to rule in my favor? Not necessarily, but then, like we always say, when it comes to litigation matters, it's how you're able to present your case and persuade the court. You need to have a strategy, especially the lawyers. You really need to just show why what you're asking for, you deserve it. And I give kudos to Mr. Wole's legal team. And now let's talk about damages. Now the reason why people ask for damage is one, it's to compensate the person, that's the plaintiff in this case now, that is suing the other party for infringement or IP theft or whatever it is that they're suing them for. It also puts you in the position that, so I'm trying to get this back from you. If you had not done this, is what I should have gotten, or this is what I should have recorded. And then he also tries to discourage infringers and third parties from the act of violating the exclusive rights that are accorded to an IP owner. So if someone, let's say the court is awarded 100 million like he initially asked for, would another telecom company or any other brand out there want to use the photographs or images of an individual, whether or not they are in the public eye or it's just a random person on the street. So that's the purpose of asking for damages. And damages are sometimes calculated based on the lost profits or reasonable royalties. That's another strategy that you can use, whereby in the event where the dispute was resolved and the person still wants to get a license from you, you agree to a reasonable royalty, and probably the court to draft the court to give you like a consent judgment where you both agree to. This case also reminded me of the Onyeka Owenu against iRocking case, that was sued because they had continued using one of her songs 2 years after the contract they had with her had elapsed. And this is similar to why I refer to this case, because of the fact that they kept using an IP owner's intangible asset without their consent, especially after the contract had elapsed, that it terminated, as expired. In Onyeka Awareness own, it was 2 years after. For Wole, I think it was a couple of months. So between December 2014 and April 2015. It's just a short period, but then it's a bold statement for a brand to want to use your intellectual property without prior informing you or paying you some sort of royalty or even acknowledging you. And again, why I refer to this was the fact that Mr. Jason Joko, who is, I think, is the founder or co-founder or co-owner of iRocking, had made a statement. It was more or less like a diss, stating that they had that Miss Onyeka, when he had only gotten 500,000 naira as opposed to the 205 million naira she was demanding as damages. And it was like, oh, when you guys are asking for the initial damage caused, you guys did the fanfare, press, whatever, because you got a lower fee, at the end of the day, range repeat. And that kind of got to me because, one, it gives people the impression that, okay, it really doesn't matter whether or not you have a good case. If you go to court, you're not really going to get what you want. But that's not true. A precedent has been set and the person has been put in his place. He's actually going to part with money. So you need to look at it from that part as an IP owner, that even if someone infringes on your work, just sue. I mean, talk with your lawyer first of all. Not just any lawyer, a lawyer that is specialized on the type of dispute that you want to go to court for. That way you get proper representation and you actually get what you want. So it should not deter you if maybe your case is in court for like 2, 3, 5 years. I mean, different jurisdiction, and I know that even abroad, I recently saw a case where, yeah, I've analyzed the case that stayed in court for like 25 years. I've reviewed cases that stayed in court for 7 years, 5 years, 10 years. So in essence, do not give up if someone sues your work. And also take note that a copyright owner can sue any third party that intends to violate their exclusive right. They can also receive a percentage of the sale price in the situation where the photograph or image was resold, distributed to the public, or used for whatever purpose that they're using it for. And in this scenario now, Airtel can't hide behind the fair dealing principle, which is mainly for non-commercial purpose, like you're criticizing someone's copyrighted work, using a parody, you're using it for research, or using it for private news or news reporting. And again, it also offers you limited purpose as to the use when it comes to you're not monetizing it, but you're using the work in a non-commercial way. So in Nigeria, we have the fair dealing principle, whereas in the US, they call it the fair use principle. Copyright infringement occurs when a third party or individual or a company uses a copyrighted work without the consent, permission, authorization, which I coined as CPA, of the IP owner. And in this case, Mr. Wole Ojo is the sole owner of this, and then they did that to actually make profit and also deprive Mr. Wole of his benefit. There's also the fact that if negotiation had actually broken down between parties, I think Airtel Network Limited should have made an offer that Mr. Wole Ojo would have considered to be, doable, to be able to accept, continuing their relationship. But they let the contract terminate. I mean, it was an exclusive agreement and not a non-exclusive one. So trying to use his image without his consent is already an issue. You already have conversations as to personality or rights of publicity. I know we don't have a proper precedent at the moment in Nigeria, but then there are strategies that one can use to be able to get headway in court. Now, one of the disadvantages of copyright in this digital era is the ease of reproduction. That means how easy it is now for someone to be able to publish your work to the public, either on an internet, on website, or on a WhatsApp group, or any other social media platform. There's practically no way to control how what happens on the internet, basically. Now, moving on to remedies. Remedies are available for a copyright infringement where your copyright has been infringed or violated, your exclusive right has been violated, your work has been used without your consent. These are the available remedies you can opt for. First will be an injunction to prevent either Airtel or any other third party or alleged infringer that is trying to exploit your exclusive right. So the courts will grant you an injunction preventing that person from committing any of the acts that they did that brought them to court. Then secondly, damages. I already talked about damages where you either take the account of, in form of an account of profit, or how much you would have made if that person had not infringed on your right, or royalty based damages. And in this particular case, the cost of a copyright infringement was worth 20 million naira. I don't know how much that is in dollars. Okay, hold on, let me do the maths so that something to work on. So I'm asking Google right now, 20 million naira to dollars. Ah, gosh. 20 million naira to dollars is $44,109. 44,000. Ah, is that money big? I mean, okay, let's do it to pounds. That's about 35,000 pounds. It's a lot of money. Oh. It is a lot of money, but I mean, I know I had this conversation with a colleague who was like, me Lord no try, why you know up the money small, but then for at least do something. I mean, 20 million seems small. I mean, for someone that asked for 100, maybe they did not show that after evaluation, this is what Mr. Wole would have gotten, and based on how they were able to persuade the judge, they ended up with the 20 million naira cost. But yeah, also know that it is not a waste of time for you to sue, as it is within your right to enforce your intellectual property right to enforce it. You can also ask for account of profit. This is how much I should have made between December 2014 and 2015. I mean, it was originally an exclusive deal, but it's no longer exclusive. So I'm open to the market. Like, everybody make on a rush me. Know that photos are eligible for copyright work and they enjoy automatic protection. For the moment, is my section 10 specifically gives the first person that creates the word authorship. So, like I've always said, authorship and ownership are different. Then other silent issues that I considered were, one, image right. Unfortunately, we do not have an express law or provisions that caters to image rights disputes. However, like I said, there are instances where you couch it in a way to show the court that, okay, this person is trying to exploit, like for Wole's case. Now, they stated that they're trying to exploit his influencer's capability, his work, and his goodwill. So, find a very innovative way to catch it that will draw the attention of the judges to be like, I see where you're going with this, and bam, you're gonna get what you want. Another thing is that when someone uses your image, it's clear that they want to mislead the general public into thinking that, okay, for instance, Wole Ojo, which is a case study, Mr. Wole Ojo has something or is affiliated or linked to Airtel. They might want to also make consumers think that, okay, Wole, if you're a fan of Wole's movie, you'll be like, since Wole Ojo is doing advert for I want to say Netflix. Since Mr. Wole Ojo is doing adverts for again, sorry guys. Since Mr. Wole Ojo is doing adverts for Airtel Nigeria, why don't I just port to Airtel? I'm about to port too, because Namova and Glo be messing up big time, but that's an aside. Then on issue of right to privacy, would you argue, just indulge me guys, and you can answer me, either you send me a voice note on Anchor here. So would you argue that Mr. Wole Ojo's right to privacy was violated in line with section 37 of our constitution, the 1999 constitution of the Federal Republic of Nigeria? The elections are pretty close, so you guys need to start taking all of this in serious. Read the constitution, know your rights. Shall just stay grounded in Nigerian law. That's on the one part. Then on the issues of thoughts of passing off, I think when I'm always talking about thought of passing off, I like to refer to the Robin Rihanna Fenty against Arcadia Group Brand Limited, which is also known as Top Shop, because I came across this case when I was doing my master's between 2013 and 2014 at the University of Derby, the University of Derby, and it kind of struck me at that time when we were reviewing this case in class. So for every time that I want to talk about this, is like my go-to case. I always like to refer to it, because in that particular case, Rihanna's image was used. Rihanna even had to get a consent from the original photographer who took the photograph during one of her video shoots for her 2011 single Talk That Talk album. So if someone who's it's my image, I have to go and meet the photographer, because I know that the first person who takes or creates the work is the author. See, I need that photo. Probably she bought it. Now in this instance, let's look at it from Wole's Ojo's case now. Mr. Wole took his pictures, or someone took it on his behalf, and probably the rights were transferred. We're just speculating now, because I haven't seen all the documents, just the judgment. And Airtel originally had an exclusive arrangement, and now that exclusive arrangement is going to elapse within a certain period of time. Now it's for you to go back and say, okay, I know this doesn't work out, but how about we license it from you? Perfect. Everybody goes on happy, and now we have a suit and a judgment worth 20 million. I'm gonna keep making emphasis on the fact that they got 20 million there. It's not like it's bad though, don't get me wrong. But what I'm trying to say is that from the Rihanna case, Topshop had in 2014 created a merch line for their t-shirt and used Rihanna, that particular picture from the Talk That Talk album. And Rihanna was like, nah, you guys can't use my image and likeness. You're going to mislead people, especially my fans, to think that, I signed a deal with Topshop. But I think I recall that they were in talks. But again, negotiation broke down. You know what? And then you just said, okay, let's just go with it. And maybe thinking that, I don't know what was wrong, what the PR guys thought, or what the media department thought, and okay, let's use it, she might come around. But she never did, and she sued Topshop. Can't remember how much she won, but that's like my go-to case I'm talking about. There are similarities between Wole Ojo's case and this Rihanna's case as well, and also the Banire's case, which I refer to, and the Oyenka Awenu. So sometimes when I'm doing my analysis, I like to refer people to different things so that they can see where I'm coming from, what is inspiring my thoughts. These are not legal advice or opinion, whatever, and I'm just sharing my thoughts about. Someone might review the case and have a different opinion, but yeah. So I was saying, for thought of passing off, you give people the impression that the person in question, for instance, not for instance, Mr. Wole Ojo had endorsed and licensed his image to Airtel to be used for the MNP services between December 2014 to April 2015, which is a clear misrepresentation as to the source of the goods. Because trademark. Okay, this is not a trademark case. Oh my gosh. Okay, but then again, it might also impact how consumers would decide that they want to either explore the Airtel and MNP services or want to buy the t-shirt by Topshop with the I mean, I love Rihanna. I mean, I'm happy she's doing fantastic. I mean, with Fenty, she just broke the table. All these, oh, we can't do 40 shades. Now everybody is struggling to do 40 shades, and she's just she's exploring, and she has her Super Bowl halftime, which everyone is looking forward to. I mean, Rihanna hasn't performed in ages, almost 6-7 years now. But yeah, we're not talking about Rihanna again. Let's move on. In a clear case of thought of passing off, Wole Ojo would have to prove that he has goodwill, he has reputation. I mean, come on, he's the winner of the AMVCA Viewers Choice Award. For someone who has won an award, I know that feeling. And when someone is trying to do stuff with your reputation, like, okay, let's put his face in. I think it was during that period when everyone was like, oh, let's get most of the winners to be an influencer or a brand ambassador. Deals were just flying left, right, center, etc., etc. Also, Airtel, guys, sorry. Airtel's behavior and that is also a misrepresentation of Wole Ojo's brand, his image, his likeness, and his influencer capability. And finally, he also caused damage to his goodwill as he made other brand think that, okay, it be like, say, Airtel Nigeria nine gets Wole for this year or for this period this year, so we know fit. I mean, you have the prime Garnets who are agents responsible for getting models and actors, into all of this kind of business arrangements. So clearly, and also, I don't really want to talk much about this, but yeah, that sums up my silent. And then I talked about matters arising and silent issues. So this is where I draw the curtain for my silent issues and move on to the next conversation. So disadvantages of litigating intellectual property related dispute. 1, processing takes time. Like I said earlier, I think there is these Louis Vuitton case that took 7 years, judgment just coming out. I've even reviewed a 10-year case, 15-year case, 25 years case. I've stayed in court. Litigation takes time. There's also unnecessary adjournment or one excuse that court not sitting or a judge is sick. It's not like it's a bad thing. I mean, we are humans, we're not robots. But I mean, they need to be. Is it be like specified number of adjournments, or I don't know. But something needs to be done as to reducing the timeline for litigating IP related dispute. As an ADR practitioner, ADR basically means alternative dispute resolution mechanism. Mediation takes less time. Arbitration takes less time as well, and it's strictly for commercial dispute. Huge commercial dispute. Another difficulty or disadvantage is difficulty in proving damages. Not everyone really knows how to prove that, okay, this is what I lost as a result of this infringement, as a result of this unauthorized use, etc. So you need to show and prove, which is where the IP evaluators or your valuation comes into place, because there's a lot of math that goes into that. We also do not have specialized intellectual property courts that have trained IP judges. I mean, the Federal High Court has jurisdiction to hear IP related dispute, but I think, and I'm of the opinion that if we have an IP specialized court or a copyright small claims court, or board like the US currently has is going to go a long way to solve some of these issues. Also train the court staffs, the judges, and ensure that the lawyers that actually appear are um, people that are knowledgeable in IP. Also give law students or third parties or people that are not parties to the dispute to, be able to see how this happens, and that way you're able to get more IP owners to. I'm not saying you guys should start suing random people, no, but let them know that the court is on their side. And then most alleged infringers and third parties, for instance, Airtel, they probably did not think that their action was illegal or it was a violation of Mr. Wole Ojo's intellectual property right. Do you get? So sometimes it's an unconscious or involuntary infringement, or it's not. But like they say, ignorance is not an excuse. You just had to whisper that just in case there's someone from somewhere that's misreading my interpretation. That's what I'm saying. But yeah, so I'm wrapping up in a bit. So my recommendation to wrap up is that, first of all, telecommunication companies such as Airtel Nigeria, Nine Mobile, Globalcom, MTN, and other internet service providers should always draw by their intellectual property department. If you don't have one, please create one. It will save you a lot of cost, save you money from IP related disputes. I mean, before you put out any content, make sure that the IP departments, the lawyers, IP is not generally for lawyers. So for very technical IP assets, you find biochemists, physicists, engineers who are within that department. But the lawyers will come in from the legal aspect, where they look for loopholes and gaps that might cause problems. You also need a good PR lawyer, someone that knows how to manage this kind of information when they get into the public, what kind of letter you should post, apology, press, just anything. Know that as a body corporate, as a corporation, you can be held liable for IP infringement, such as copyright. You can be held liable for IP theft or any IP violation of the exclusive rights accorded to a copyrighted owner, either right to publish, to broadcast, to communicate, to create cinematography work, to translate, adapt, to license, sell, whatever it is, whatever because copyright protects literary and artistic works. So read Section 1 of the Nigerian Copyright Act. Then always carry out an IP due diligence. Very, very important. That way you're able to determine the chain of title going forward, so you know who to meet, who not to meet. How much do I pay? XYZ. Just saves you money as well. And finally, if the image or the photograph and yours, if it's not your own, please verify the chain of title and do the needful by getting the rights, consent, or license from or assignment from the copyright owner. Which in this case, the court decided that it was Mr. Wole Ojo. So Airtel, apologies, you guys have to pay 20 million naira in these Buhari times, but I guess it had to be done. It really had to be done, and we need more of these cases as well, more of this precedent, so we'll be able to derail. Like I was telling my friend, I say, if I was the judge, 50 million, kaka, the lawyer's fee, or attorney's fee, the 1 million plus interest, that kind of thing. But then for big corporations who don't see all this kind of money as anything, would they really be deterred from using someone's intellectual property without their consent? Not really. Take a good look at the Please Call Me Back case, Vodacom case with the inventor of Please Call Me Back. Vodacom have been dragging that case for about 25 years. Court has given judgment. They've done assessment. court have said this is how much you're supposed to pay, and Vodacom is like, no, this is not how much you're supposed to pay. So many issues with enforcement, not just from the courts or from the security agent, but from the infringers themselves. So I hope we do better this year. I mean, we need more IP cases in 2023 and more judgments, but that means a lot of work for the judges and for the lawyers and the law firms who will be involved in all of these things. So I hope I've been able to make a good case and explain myself better. You guys can check out the Twitter version, the LinkedIn version. This is a final podcast version. So, yeah, always open to hearing from you guys. If you have cases you want me to review, please let me know and I will do my best. So we've come to the end of our second episode for 2023. And we're inching closer to our 100 episodes. So yeah, thank you guys as always for listening to me talk about intellectual property. Don't forget to like, share, subscribe, save, favorites. Yeah. And see you guys in the next episode. Cheers.